Go ahead and get started. Hello, everybody, and welcome to our latest online learning session, Decoding the Chevron Doctrine ruling. I'm Katie Moss, and I serve as FLA's Director of Stewardship Initiatives and Regulatory Affairs. And I'm joined today by Charles Yates from the Pacific Legal Foundation, who's going to talk to us today about the recent ruling from the Supreme Court to overturn the Chevron Doctrine and how this could affect regulations that impact private forest landowners. So something that we discuss a lot as an organization is the importance of regulatory certainty, and that if landowners know what to expect in the regulatory space, they can better prepare for the long-term investment of owning and managing forest land. So while the repeal of Chevron does disrupt that status quo that we've had for about 30 years, and will lead to some uncertainty for the regulatory landscape going into the future, it also really provides an opportunity for more fair and balanced regulations for private forest landowners, and also an opportunity for us to potentially work more closely with the agencies to provide them with the feedback and the data on the front end that could potentially help avoid litigation. So this is new territory that we are all going to be figuring out in the coming years as the impacts of this ruling continue to shake out. But we're really excited to get Charles's perspective as someone who works on cases every day that deal with Chevron deference. So before we get started, I wanted to go over a few quick housekeeping items. Please note that your microphone is muted, so if you have any questions, we will address them at the end of the presentation, but you can use the Q&A feature and the chat function to ask your questions. Also, this session is being recorded, and the full recording is going to be sent out to you via email later this week. So to kick us off, I'll give a little background on today's speaker. So Charles Yates is an attorney with the Pacific Legal Foundation's Environmental Law Project, where he litigates to defend private property rights and uphold the structural protections guaranteed by the Constitution's separation of powers. His inspiration to focus on environmental law comes from the special case of government overreach it presents, where individual rights too often give way to collectivist notions, and where misguided government policies create a cure worse than the disease. Charles has a particularly strong belief in the important role that the productive use of natural resources plays in human flourishing. So to these ends, his practice focuses primarily on the Clean Water Act, the Endangered Species Act, and other related federal regulatory schemes. Charles was a member of the litigation team representing Michael and Chantel Sackett before the United States Supreme Court in their landmark challenge to EPA's assertion of regulatory authority over their property. And he's also represented landowners, ranchers, timber operators, oil and gas producers, local governments, and trade associations as lead counsel before numerous federal trial and appellate courts. In addition to his work as a litigator, Charles has appeared on a variety of national television and radio programs, has addressed numerous professional and industry gatherings, and has been quoted in the Associated Press, Reuters, the Washington Post, Reason, the San Francisco Chronicle, and E&E News, among other publications. Charles is also a member of the California State Bar and various federal district and appellate courts. Charles earned his JD magna cum laude from the University of Baltimore School of Law and holds a BA from the University of Western Australia. During law school, he served as president of his school's chapter of the Federalist Society and was an editor of the University of Baltimore Law Review. So Charles, thank you so much for being here with us today to inform our members about the possible impacts of this landmark decision. And with that, I will turn it over to you to tell us more.
Yes, well, thank you, Katie. I appreciate it. And thank you to Forest Landowners Association for having me speak. I really do appreciate it. So first, I'll provide a little bit of background about PLF and sort of what our interest is here. So PLF is the nation's oldest public interest law firm litigating to defend private property rights and fight government overreach. We're a non-profit law firm and we represent all of our clients free of charge. Now, many of PLF's most important victories at the Supreme Court and in other courts have involved environmental law and natural resources issues. And so to that end, we have a specialized environmental practice group of which I'm a member that litigates these natural resources issues on behalf of producers and private landowners. Now, through bringing strategic cases to challenge federal environmental overreach, our goal is to ensure that private property rights are respected and to rein in really the worst abuses and excesses of the federal administrative state. And I should note, and I'll address this a little bit later in my remarks, I think as many of you are aware, PLF is representing Forest Landowners Association, along with a group of landowners from Southwest Alabama, in a challenge to the United States Fish and Wildlife Service's designation of critical habitat for the black pine snake. Now, as for my remarks, as Katie mentioned, I'm going to address the United States Supreme Court's decision in the companion cases of Loper Bright Enterprises versus Raimondo and Relentless versus United States Department of Commerce. And as Katie noted, in those cases, the Supreme Court overturned the legal doctrine known as Chevron deference. Now, the reason I'm speaking about this topic is really the significant implications for environmental policy and regulation that it will have going forward, and therefore its implications to forest landowners and other producers. Because in many respects, the rise and demise of Chevron deference was a story about environmental law. Chevron was itself an environmental law case. Loper Bright was an environmental law case. And in the intervening 40 years, Chevron was applied in literally thousands of cases to uphold the federal government's often broad environmental regulations. So I'm going to set forth my remarks in two parts. First, I'm going to provide some background in which I explain the Chevron doctrine as well as the decision in Loper Bright. And then second, I'm going to discuss the implications of the Loper Bright decision, both more generally and as specifically applied to environmental law. So my remarks will go for maybe about 20-25 minutes, and then I'm happy to stick around for as long as necessary at the end to answer your questions. So I'll start at the beginning with the background. Chevron versus Natural Resources Defense Council was a 1984 challenge by a set of environmental groups to the Reagan administration's Clean Air Act regulations dealing with stationary sources of air pollution. In that case, those environmental challengers had argued that the regulations violated the Clean Air Act because they were too narrow. Now, the case was pretty technical and arcane, dealing with specific provisions of the Clean Air Act, so that doesn't really bear a lot of analysis for this discussion. But what was really significant was the interpretive framework that the Supreme Court adopted for determining whether those challenged regulations were lawful and consistent with the Clean Air Act. And it proceeded in two steps. First, it addressed whether the Clean Air Act had clearly spoken to the issue before the court. Were the regulations clearly lawful or unlawful under the text of the statute? Now, because the court found that the Clean Air Act had not clearly spoken to that issue, indeed it was arguably quite ambiguous on that front, the court proceeded to a second step. And under that second step, it deferred to the government's regulations merely because those regulations were reasonable, minimally rational. Now, at the time, Chevron really went unheralded. It was quite unremarkable. It received very little attention in the press or generally. However, within a few years, it had really grown into a monster which fundamentally altered the operation of our government. Such by the late 1980s, many decisions from across the federal courts were applying a version of that two-step framework from Chevron. And again, first step, did the Congress directly address the issue at hand? If not, if the law was ambiguous, the courts proceeded to a second step in which they would consider whether the agency's interpretation was simply reasonable. Now, the agency's interpretation didn't have to be the best interpretation. It just had to be reasonable or minimally rational. And I think another point that's really important on that front is very rarely, throughout the 40 years that Chevron was on the books, very rarely did we see courts ending the analysis at that first step. Instead, we saw a pattern emerge where the courts gave really short shrift to party statutory arguments, legal arguments under the law, and instead would just sort of reflexively find a statute ambiguous and thus defer to whatever the government had offered them. So in effect, in any litigation involving the government was at an automatic advantage. If the law from Congress was unclear, as a law from Congress often is when you look at it for the first time, well, then the tie went to the government. Now, that era, the Chevron era, came to an end on June the 28th of this year when the Supreme Court issued its decisions in Loper Bright and Relentless. Now, those cases involved groups of North Atlantic herring fishermen challenging implementing regulations under the Magnuson-Stevens Fisheries Conservation and Management Act. Now, these regulations required that the fishermen expend very large sums of money to have on board their vessels paid monitors to ensure that they were complying with various bycatch requirements. Now, the lower courts deferred under Chevron, and this sort of illustrates how Chevron worked. The lower court said, well, the statute's not really precise on the issue, and what the government has offered up is at least a minimally reasonable justification for imposing these costs. So the government gets the benefit of the doubt and basically wins. Now, the Supreme Court reversed. And importantly, in doing so, it explicitly overturned the Chevron Doctrine that was applied by those lower courts. Now, the Supreme Court's reasoning was pretty straightforward. The Supreme Court essentially said that it's the role of the courts to interpret the law, and that doesn't change just because one of the litigants in the case happens to be a federal government agency. So Loper-Bright, it essentially reaffirms a long-standing, and in my opinion, fairly uncontroversial proposition that judges must interpret laws in the first instance, and that the courts are not obliged to favor any one litigant's interpretation of the law unless that interpretation is convincing. So the courts must now, in the wake of Loper-Bright, they must now look at the arguments that are made on both sides of a case involving the federal government, and they must decide in the first instance, the challenger or the government, who has the better argument. So moving on to discussing the decision's implications, and I'll discuss the implications sort of more generally and also specifically to environmental law issues of relevance to this group. Now, the way I want to approach the discussion of the case's implications is really to frame it in terms of the three constituent branches of our government: legislative, executive, and judicial. As we all learned in our high school civics classes, our government is comprised of these three branches. We have a legislature, the people's elected representatives, the Congress that debate policy and pass laws, an executive branch, the president and his agencies who apply and enforce those laws, and the judiciary, judges in the court system who interpret the laws and adjudicate disputes arising under them. Now, this separation of powers provides important checks and balances on the three branches of government to ensure that no single individual in our government becomes too powerful. So you've indulged me on the sort of high school civics component of my remarks, but the reason I want to approach the discussion this way, because I think it does have practical implications, is that because while Loper-Bright was a fairly sort of technical statutory question dealing with the standard of review that courts apply in agency litigation, at bottom, it was really a decision on this constitutional separation of powers. So what I'm going to do is I'm going to discuss what I anticipate might be the general impact of Loper-Bright on each branch, and I'm going to tie that to some specific issues in environmental law that would be of relevance to this group to sort of illustrate how things might change going forward. So I'll begin with the decision's impacts on lawmakers in Congress, and this is necessarily, I think, one of the more abstract implications of the decision. But for a lot of years, the Chevron Doctrine more or less allowed Congress to abdicate its responsibility to legislate because it essentially shifted the policy-making function from our elected representatives in Congress to unelected bureaucrats in the executive branch agencies. Chevron really allowed Congress to avoid passing legislation on controversial or significant subjects, like, for example, climate change, and instead just passing very broad and ambiguous laws to allow the agency to have the benefit of Chevron and sort of do the heavy lifting. Now, as you can imagine, politicians absolutely love this because they could have their cake and eat it too. If what the agency did was politically popular, well, they could take credit for it. They could point to the statute. But if what the agency did was unpopular, well, they could blame the agency and claim they never voted for what the agency did. And all the while, the members of Congress didn't really have to do anything that might jeopardize their chances of being re-elected. I think it's worth noting that many scholars have opined that Chevron deference is at least a partial explanation for the presently dysfunctional state of our Congress. Now, with no Chevron, the agencies are far more constrained in what they can do with congressional laws. So if an agency is going to do something significant or controversial, address some sort of major environmental or social problem, well, there needs to actually be a law from Congress directly and quite explicitly directing them to do so. So this means that Congress needs to actually start passing laws again. Now, whether that actually happens is another matter that's sort of well beyond my area of expertise, but that's at least the general implication for lawmaking of the Chevron decision. Now to the executive branch, the president and the federal agencies. Now, Chevron at its core really gave extraordinary leeway to federal agencies to pursue the policy priorities of the current presidential administration. Because there was a sort of marked lack of meaningful judicial scrutiny in how the agencies were to apply and enforce federal laws, well, this meant that they could really make it up as they went. So, a statute without actually changing in its text one bit could mean one thing while a Democrat was in office and something completely different when a Republican took office 4 to 8 years later. So by giving agencies this incredible leeway to interpret ambiguous laws, Chevron really engendered the sort of wild swings in federal regulation that we've all become so accustomed to. And I think a very good example of this that would be relevant to this group are the WOTUS regulations that we've seen over the last 15 years. As many of you know, the Clean Water Act's permitting regime is governed by this statutory phrase, navigable waters or waters of the United States. That's the WOTUS acronym. Now, if a particular feature is a WOTUS, then the Environmental Protection Agency and the Army Corps of Engineers can regulate your land. If the feature is not, then they cannot. Yet, every administration since George W. Bush has concocted a different definition of WOTUS. President Obama had the Clean Water Rule in 2015. President Trump had the Navigable Waters Protection Rule in 2020. President Biden did his own rulemaking in 2023 that's currently being litigated. Now, even though the text of the Clean Water Act stayed exactly the same throughout that time, during the 15 years that this was all going on, Congress did not amend at least the WOTUS provision of the Clean Water Act. However, these agency definitions, they vary drastically. And I think it's really fair to say that each one is fairly characterized as a complete 180-degree shift from the last. So every 4 to 8 years, with the changing policy preferences of the presidential administrations, the entire scope of the Clean Water Act, like what you do or do not need a federal permit to do on your land, changed. Now, as you know, this constantly changing approach engendered extraordinary regulatory uncertainty because EPA could keep changing its mind about how to apply the Clean Water Act. And then as soon as it was sued in court, well, it could cite Chevron and argue that, well, the WOTUS phrase is ambiguous in some way, and therefore at least attempt to convince a court to uphold whatever they were deciding to call a WOTUS at that given time. Now, the end of Chevron deference means an end to that sort of regulatory ping pong. It's now up to the courts and not Biden's EPA or Trump's EPA to say what the law means. So the demise of Chevron, if nothing else, should ensure greater regulatory stability as courts begin to opine on the meaning of these federal statutes. Now I'll address the judiciary now. So what does the end of Chevron mean for the courts, and specifically judicial review of federal agency action? Again, I'll go back to the high school civics component of the remarks, because in Loper Bright, one of the first things that Chief Justice Roberts did was cite Chief Justice Marshall's famous declaration from Marbury versus Madison. It is emphatically the province and duty of the judicial department to say what the law is. Now, Chevron violated this foundational concept because it shifted the court's duty to say what the law is onto federal agencies who were given the benefit of the doubt. So in many cases, federal agencies truly got the final say on what the law means. So long as a statute was ambiguous, the agency's interpretation was minimally rational, their interpretation prevailed. Now, Loper Bright ends that in favor of more robust judicial review of agency regulations. Now, in litigation involving federal agencies, the courts will treat agencies and the regulated public as equals. Whoever has the most persuasive argument wins. And a specific example of this that's relevant to this audience would be Forest Landowners Association's Endangered Species Act litigation with the US Fish and Wildlife Service over the critical habitat designation for the black pine snake. Now, in our black pine snake case, we've asserted a variety of different claims for relief, but essentially our case boils down to two sort of primary arguments. First, because only a small handful of snakes have been seen in this large area designated over a very long period of time, the area is not quote unquote occupied for purposes of the Endangered Species Act. And as a result, that means that the Fish and Wildlife Service didn't have the statutory authority to designate occupied critical habitat under the Endangered Species Act. Our second sort of primary argument is that by ignoring and discounting a whole bunch of the economic impacts of this designation, the Fish and Wildlife Service violated those provisions of the Endangered Species Act that require them to do cost-benefit analysis. Now, in our case, which was filed way back in 2020 and briefed through 21, 22, the very first thing the government did to defend itself was invoke Chevron deference. The government argued that the term occupied is ambiguous and could mean something different depending on sort of different biological circumstances. So they essentially argued that whatever they say occupied means automatically carries the day. They're the experts, and Landowners, Forest Landowners Association, PLF, has absolutely no business making any arguments to the contrary. Second thing they did was they argued that because the cost-benefit requirements of the Endangered Species Act don't explicitly spell out in sort of microscopic detail how cost-benefit analysis is to be done, well, that means the Fish and Wildlife Service can do cost-benefit analysis however it wants. So they basically argue that they should win the case automatically because the ESA is in some respects ambiguous, and they've put forth a sort of minimally rational interpretation of it. Now that Chevron has been overruled, the court in our case has far more leeway to look at our arguments. It can now decide for itself who has the better argument regarding the ESA's requirements, Forest Landowners Association or the government. Now, one thing I should do or should make clear is this doesn't mean that we automatically win the case. What it does mean is that the government does not automatically win the case merely because they've invoked Chevron. Now, we filed a notice informing the court of the end of Chevron deference, and we hope that the court will decide the case soon. Now, just briefly, before I conclude my discussion, I do want to sort of briefly touch on one additional topic, which I think matters greatly to this group. And this being whether we can expect the demise of Chevron to have a sort of generally more pro-regulatory or deregulatory impact. Now, in reality, I don't think the answer to that is quite so simple, because the operative question when we're talking about Chevron or lack thereof is not about regulation versus deregulation. It's about essentially whether the agency had the authority from Congress to do what it did. So, for example, in overruling Chevron, the court struck down as excessive a heavy regulation on commercial fishermen. So the demise of Chevron had a sort of deregulatory impact there. But remember, Chevron itself involved a court deferring to and thus upholding a Reagan-era Clean Air Act regulation that would have eliminated certain burdens on the regulated public. Now, the precise impact of deference or a lack thereof on regulation is therefore essentially sort of governed by whether the agency's priorities, be they regulatory or deregulatory, line up with the explicit requirements of the law. Now, with that said, that's sort of a non-answer. I do think we can expect the decision to generally lessen burdens on the regulated public for three reasons. And without holding me to it, I sort of have a few predictions here. So the first reason is, since the Reagan era, the administrative state has fundamentally changed. It's a bit of a generalization, but modern administrative agencies tend to suffer from a sort of severe tunnel vision when they're approaching specific issues within their bailiwick. Because at this point in history, we really have seen far more adventurism in agencies applying statutes to expand their power and far less to retract it. So to go back to the WOTUS issue, even the Trump administration's WOTUS rule, while certainly narrower and an improvement over the Obama rule, it still asserted broad authority in many ways that were not permitted by the Clean Water Act. And this has subsequently been confirmed by the Supreme Court in Sackett. So there's something to be said if even the Trump administration's EPA engaged in a degree of pro-regulatory adventurism that would not pass muster under a strict reading of the Clean Water Act. Now, second point, during the last 40 years, the courts have also changed. So during the 1970s and 1980s, the sort of judicial backdrop to Chevron, courts were generally far more activist. This was sort of the heyday of purposivism, which meant that without deference, certain courts, particularly the DC Circuit Court of Appeals, were liable to strike down deregulatory agency action as being out of line with some generally broad view of a law's purpose. Now, since then, by and large, federal courts have embraced textualism. Modern courts in 2024, are far more concerned with strictly analyzing the precise terms of governing statutes in line with their texts. So, and just generally speaking, this is born out of my own experience, broad agency regulations tend to fare poorly when they're subjected to that sort of textual, strict analysis. What did Congress actually say? Whereas a narrow regulation, again, generally, is more likely to be in line with the text because it doesn't involve that sort of adventurism that sort of brazenly goes beyond what Congress has required. Now, the third and last thing I'll say on this point is that really, if nothing else, I believe the regulated public will benefit greatly from the increased certainty engendered by agencies no longer being able to wildly shift their approach to regulation every 4 to 8 years, sort of from one administration to another. Loper-Bright really, I think we can say, brings to an end the sort of regulatory ping pong that we saw in the WOTUS context. So with that, I'll conclude. So I've provided a little bit of background on the Loper-Bright decision, and I've discussed its implications both generally and specifically as to environmental regulation. I really appreciate you having me, and I'm glad to stay on for as long as necessary to answer your questions.
Awesome. Thank you so much, Charles, for sharing your expertise and your outlook on the impacts of the Chevron decision. Incredibly insightful, and I know really, really helpful for us to help us kind of wrap our heads around what this means for private forest landowners. So we will open the floor up for any questions. And I see one in the chat right now. Can existing ESA regulations be challenged, or only regulations which have not yet been finalized? Yes.
So there's a couple of things there. So the first thing is we're constrained by the statute of limitations, right? So generally speaking, there's a 6-year statute of limitations to challenge federal agency action. Now, if there's no previous challenge been filed to an ESA listing or regulation, and you're still within the limitations period, well, generally speaking, that would mean that you could proceed in challenging the rule, and you would be governed by the new standard of review. That's sort of a general answer to that. So question of the statute of limitations, and there's a lot of things that go into that based on specific circumstances, but a sort of more interesting point on that as well. So that's sort of just the sheer mechanics, of when you can challenge agency regulation. More interesting point is the Supreme Court was somewhat concerned in Loper-Bright with completely turning over the apple cart. So there's some language towards the end of the decision dealing with the sort of precedential effect of the Loper-Bright decision. And the Supreme Court essentially said that regulations that have previously been upheld under the Chevron framework, the cases upholding those regulations aren't automatically sort of bad law just because Chevron has been overturned. So certain regulations that have already been challenged and upheld under Chevron, that precedent potentially still stands, but that's really an open question. The Supreme Court's sort of treatment of that issue was really vague, and I suspect it will be extensively litigated. I imagine the government is going to advocate for a very broad view of that rule. So we'll see. That's sort of one of the next frontiers of Chevron deference is what can be challenged now.
Great. Thanks, Charles. We have another question in the chat. Do you think that Loper-Bright is part of an overall philosophy of the court to decrease the authority of the executive branch while increasing the authority of Congress?
Yes, I think that's fair to say. I mean, I think that the current Supreme Court is far more concerned with the constitutional separation of powers, sort of what I discussed during my remarks, far more concerned with applying the sort of original public meaning of the Constitution to pare back some of the extreme sort of creep that's occurred with executive branch agencies to ensure that elected representatives in Congress are actually setting policy. So I do think that the Loper-Bright case touches on that issue, and certainly the concurrences from some of the concurrences in the decision specifically address that constitutional issue. But I do think that's a fair characterization. I do think that Loper-Bright is a constitutional separation of powers issue at bottom.
Excellent. Thanks, Charles. Another question from the chat. How will this change affect decisions not to list a species under the ESA, as in the case with the gopher tortoise?
Yes. And listing decisions are interesting because that goes to sort of another wrinkle in how deference generally is applied. So generally speaking, when the federal government defends a decision to either list or delist a species, we're often talking about something that's somewhat subsequent to the interpretive sort of legal framework of Chevron. And we get into this territory where we're talking about sort of fact deference, right? So that's something that's spoken about. There's a distinction between legal deference, right? Who gets the final say on what the law means, and fact deference, right? Which is, well, did the agency do its math correctly, right? And Chevron doesn't really change the approach to that second form, or the Loper-Bright doesn't really change the approach to that second form of deference, sort of just looking at these really technical questions. Did the agency, read this study correctly and do its math properly? There is still a degree of deference under the APA's arbitrary and capricious review that applies there. Now, this is kind of interesting because I think this is another frontier, is I anticipate that federal government agencies, and we're already sort of seeing this, now that they don't have the benefit of Chevron, are going to start trying to repackage everything that would have previously been listed or previously been litigated under Chevron as a fact deference question. So they're going to say, this isn't really a question of law. This is actually a question of fact. And it's going to be up to the courts to sort of sort through those mixed questions of law and fact. Now, an interesting point is Justice Kagan, in her dissent to Loper-Bright, actually specifically identified ESA listing decisions for distinct population segments as something that they could be affected by the demise of Chevron. So that's sort of an open question, but generally speaking, an agency decision not to list a species proceeds under a very narrow standard of review, which is sort of essentially, did the person who petitioned to have the species listed present this, incredibly compelling case that the species should be listed. So I can't make any specific predictions about the gopher tortoise or other similar cases, but I do anticipate that those sort of decisions are less likely to be disrupted by the demise of Loper-Bright, or the demise of Chevron in Loper-Bright.
We have another question from the chat. So this decision will make Congress create laws or write laws more clearly. But really, could this potentially lead Congress to be more likely to make no laws, which would in turn favor the Federalist Society view?
Well, yes. So there's a couple of things in there. So Congress has to write laws, and if they want to address sort of broad social or other issues, they need to pass legislation to do so, because they don't really have the same leeway to just sort of say, well, an agency can do whatever's necessary and appropriate and leave it to the agencies. Now, what the specific impact So that's sort of at a sort of abstract level how this will operate. It's essentially removed sort of or taken back the sort of policy-making authority to the people's elected representatives in Congress. Now, the actual practical implications of that for Congress, how this will actually change how Congress operates, is probably a broader, sort of more political and cultural question that I am woefully unqualified to opine upon. There are, sort of on an abstract level, people have noted the impact Chevron has had in leading to this dysfunction in Congress, but there are other factors leading to dysfunction in Congress, and I'm not really in a great position to opine on what the next Congress will look like after this election and how things might change.
Excellent. Another question from the chat. Do you believe that agencies will change the way they operate now that Chevron deference has been overturned? Or will legal challenges still be necessary to remind them that they no longer have Chevron deference?
I think the answer to that is sort of yes to both questions. So I do think the agencies will change their practices, and we're already seeing this. So in Federal Register notices, we've already been seeing the agencies spend, when they say designate critical habitat, or we saw this with the Biden administration's implementing regulations for the Endangered Species Act, which actually came out before Chevron was overturned, but I think they knew what was coming. They spent a lot more time actually analyzing the text of the statute. They spent a lot more time justifying their position in line with what the statute actually says, because they know that that's how they're going to have to defend it when they go to court. Now, that being said, I don't think that Chevron will sort of, or the demise of Chevron will sort of automatically bring to an end many of the worst excesses of the administrative state. These agencies are still going to be operating, and they are still incentivized to expand their power to the extent possible. So there will certainly be litigation. That litigation will just proceed a little differently. And I do think there may be less litigation over certain issues where the agencies quite clearly don't have authority and therefore don't proceed. But there's a lot of sort of issues that have to be worked through because the agencies are already sort of working to minimize the impact of Loper Bright on their rulemaking authority with a variety of arguments.
All right, another question from the chat. How will this decision affect regulations by local governments? For example, what permits are required to manage vegetation on private property?
Yeah, so it shouldn't have any direct implications to local government regulation, not direct. It may have some implications where, for example, when we're talking about like the Endangered Species Act, for example, where there are local or state regulations that exist to implement federal requirements under the Endangered Species Act. So if the federal requirements under the ESA change, that'll possibly mean that some of these sort of local permitting requirements that follow from that may change. So no direct impact in that respect. Another thing, this is sort of ancillary to the discussion here, but many state courts have also had versions of the Chevron Doctrine. A lot of them haven't. For example, believe it or not, California never had anything like Chevron deference. We always had de novo review of agency regulations in California, which certainly didn't prevent the California state government from heavily regulating. But in recent years, we've also seen, sort of as Chevron has fallen out of favor at the federal level, we've also seen a number of state Supreme Courts also overturning their state version of the sort of deference doctrines. And that could also affect sort of state and local permitting regulations and things of that nature.
Excellent. This looks like it may be the last question for now. One of the primary concerns under Chevron seems to have been the inconsistency in regulation and enforcement, especially from one presidential administration to the other. Post-Chevron, those decisions will now largely fall to courts and judges with various jurisdictions. How can we be sure that the decisions will create greater regulatory certainty, given that judges in various states, districts, etc., will likely have differing opinions and interpretations?
Yes, that's a fair question. And we saw that with the WOTUS rule, right? So one aspect of that whole WOTUS saga and mess was the fact that we had this wild seesawing between administrations. And we sort of had an additional issue, which was we had this sort of blanket patchwork of WOTUS rules because there were preliminary injunctions maybe in one state and not in another due to the actions of individual district court judges in entering injunctions. So since judges have more authority now, well, they always had the authority, but since judges are able to really look at the text of the statute and sort of enter relief against agency regulation, we may see that happen to an extent. But the structure of the court system itself provides a sort of check on that patchworking that can occur as individual district judges have differing opinions, right? If we have, differing opinions as between two districts, generally, invariably in these large regulatory disputes, we have an appeal that goes to the Court of Appeals, and the Court of Appeals settles it. And then if a circuit split, forms between various courts of appeals, and we have the Supreme Court to standardize things. And that's sort of what we saw with there was a lot going on in the Sackett decision, but that's one thing we saw in the Sackett decision was there was this mess that had sort of been created by, varying legal rulings on the meaning of WOTUS, combined with the fact that the agencies were changing their mind every 5 minutes. And the Supreme Court then intervened at that point to decide the Sackett case and actually, issue a decision with a clear rule that now governs the agency's conduct and governs the rules applied in the district courts.
Katie, I had one quick question. I know we've seen some early action. I know it's only been a few months since June, since the overturning of Chevron. It looks like Michigan versus EPA is an early case out of the gate. Are there any cases out right now that are utilizing overturning of Chevron? And if so, are those any indication or predictors of what we might see to come?
Yes. So there have been decisions issued in the wake of Chevron being overruled. And those cases have generally applied a sort of de novo standard of review. So essentially what it's looked like so far is we just get Chevron step one, right? The court looks at the text of the statute and decides, regardless of whether it's ambiguous, what the best reading of the statute is. And we've seen a few courts do that. We also saw a few courts in the lead up to Loper Bright reaching similar decisions, because Chevron almost suffered a death sort of by 1,000 cuts, because as it was realized sort of how unworkable it was, all of these different preconditions and requirements were placed on Chevron deference. So courts actually had a pretty wide ability or a decent amount of leeway to avoid Chevron if they really thought that the agency's regulation was illegal. So I think we'll see that continue. And but I really do think, like, at this early days, the biggest change that we're seeing, at least in my own cases, is the government's approach to these issues. For the first time in my career, I'm seeing DOJ make statutory arguments, make textual arguments about what a statute means, rather than just immediately invoking Chevron and asking for deference.
Excellent. And then one more question in the chat. What was the joint Loper case?
Yes, so the companion case was Relentless versus United States Department of Commerce. So that case dealt with the same regulations, these bycatch monitor regulations. It came out of a different circuit. Loper Bright, I believe, came out of DC. Relentless came out of the First Circuit. Now, I think the reason why a companion case was granted, even though it was dealing with substantially the same legal issue and the same regulations, was that Justice Jackson, because she had sat on the DC circuit, and I believe may have been on the panel that decided Loper Bright the first time in the lower court, she was required to recuse herself from the decision in the Loper Bright case. So only 8 justices decided Loper Bright, whereas there were 9 justices who decided the relentless case. So I believe that's the reason there could be any number of reasons, but that's my view of why the second companion case was granted. But the decision itself is the same. The Supreme Court issued one opinion. It didn't issue separate opinions. They obviously issued separate judgments in the 2 cases, but the opinion itself, as it appears in the United States Reporter, is just the one decision: local, bright, and relentless.
Excellent. Okay, well, that looks like all of the questions that we have. So Charles, thank you so much again for taking the time to talk with our members about this decision and kind of give your outlook and share your expertise. We really appreciate it. And if anyone has any lingering questions in the future, please feel free to reach out to us here at FLA, and we will work with you and get those answered. So thank you all for joining us. And we really appreciate you again, Charles, for taking the time to talk to us today.
Thank you for having me. I appreciate it.
All right. I hope everybody has a great day.